when it comes to voluntary bankruptcy, there are a number of requirements that have to be met for business bankruptcy. Not as much for liquidation as for reorganization, because on the reorganization side, there are requirements about not unduly detrimenting certain classes of creditors, having approval of an affected class of unsecured creditors, all secured creditors being fully paid under the plan, and then just overall the court deeming the plan feasible based upon all circumstances. There are a number of requirements in that regard. So the next topic becomes involuntary bankruptcy. But involuntary bankruptcies apply in the business context when creditors of the debtor can subject the debtor, not under the consent of the debtor, but subject the debtor to the bankruptcy process by filing a petition for Chapter 7 or Chapter 11 bankruptcy with the court. And what the creditors have to come forward with is that either 3 creditors have to have a combined claim against the debtor for $15,325 or more, all right? And this is a good faith, undisputed debt that's not being paid by the debtor, okay? Or it can be 1 creditor, not 3, has debt of this $15,325 or more, and the debtor has fewer than 12 total creditors. Now, this showing is just required to make certain that a creditor isn't unduly subjecting a debtor to the bankruptcy process out of vengeance or spite, or when there is just one disputed debt there, but the debtor generally is paying their debts. Now, if the debtor contests this bankruptcy petition, the court will evaluate to see whether the debtor is indeed paying their debts as they come due or within a reasonable time thereafter, or within 120 days prior to the bankruptcy petition had a supervisor or custodian been appointed over the debtor's estate to execute a lien against the estate or to carry out the execution of a lien against the estate. If either one of these are true, then the good faith debts exist, then the court will subject the debtor to the bankruptcy process. Now, any bad faith claims against the debtor, that is, just used as abusive tactics against the debtor, could be met with a judgment by the bankruptcy court against the bad faith claimant, which could include fines plus court costs, etc. So by and large, this is the process of voluntary and involuntary bankruptcy filing. We'll talk in greater length about the voluntary filing requirements for a business bankruptcy in subsequent videos.